SJC-11615, Commonwealth versus George Philbrook.
Thank you.
Ms. Caddick, good morning.
Good morning. May it please the court, Elizabeth Caddick for George Philbrook. In a case where the defense was that the defendant, because of organic brain disease and poorly prescribed medications, acted compulsively and was unable to conform his behavior to the requirements of law at the time of the offense, it was prejudicial to admit multiple evidence of crimes that required planning. The fact that the defendant could plan acts did not negate the fact that at the time of the crime, he was unable to conform his behavior to the requirements of law. And this particular evidence was highly prejudicial because the culmination of the events that the Commonwealth alleged is that Philbrook was on his way after the shooting to the place where he worked, where he had just been fired a day or two before, and he was very angry, and there was evidence that he had reloaded his weapon, had a full magazine, and had an extra magazine in his pocket full of bullets. And the implication was that not only was he going to kill Passius, the man that he had hit with a bat 2 days before, but that he was angry at his ex-employer, and the implication was he was going to, with all those bullets, kill more than one person. This was highly prejudicial and unnecessary. It was totally preserved from pretrial hearings, pretrial motions, and motions during the trial. Now, the evidence of the crime itself was that
How many days before the crime itself? It was like one or two?
2 days.
Well, the assault was 2 days before.
Right.
He was, after he killed his wife, he was heading to kill someone else.
That was the evidence that was presented and that the jury was told to assume. And
Sorry, is your claim that he didn't appreciate the wrongfulness of his acts?
no, in fact, the expert said that that was not what he was saying. At the time of the shooting of Dorothy Philbrook, the expert said, no, I'm not arguing, I'm not claiming that he didn't appreciate the wrongfulness. It's that because his behavior was so compulsive, and the expert not only talked about the objective evidence of his brain disorder, which was suspected to possibly be dementia, but certainly was organic brain disease from multiple illegal substances or alcohol, but also head injuries, and the medications he was given, and in particular the Requip, the medication that he was prescribed just a month or two before, and that is known to cause compulsive behavior.
So in other words, he just couldn't help himself?
The triggering event, yes, the triggering event spurred him to act compulsively.
No, he knew it was wrong. He just couldn't help himself. He couldn't
Right.
stop himself. That's your point.
Right, and it wasn't premeditated. That was, yes, that was the defense.
But if he was unable to conform his conduct with the law, which I guess is your claim, when he shot her, that's your claim?
Yes, that was,
Then
Yeah.
would it not be relevant that moments later he goes back, reloads, and is headed towards the place where he has a vendetta against the person he had hit with a bat 2 days before?
I don't know that it was moments later. He was arrested, I think the evidence was 1 to 2 hours after the shooting. I don't think that there shouldn't be much of a dispute that there was a triggering event that caused him to shoot Dorothy Philbrook, which distinguishes it from the events dealing with Ernie Passius. there was a telephone conversation that he overheard between the victim and the son, where she had said, I'm going to lock him out, no, he's locked me out, I'm going to call the police on him. And Philbrook yelled over the phone, you're going to call the police on me. And then it was after that that he shot her. And so there was this triggering event. The Commonwealth never argued that he planned this. He didn't lay in wait for her as he did with Passius. I mean, he planned the bat attack with Passius. He brought the bat with him. He was talking calmly to fellow members of the club beforehand, and as soon as Passius came out, he then went after him with the bat.
But by the way, I couldn't quite, he was holding the bat in his bike?
Yeah, he had a water bottle.
How big is the bat?
Well, I don't know, but apparently there was a water bottle holder, and instead of putting the water bottle in there, he put the bat
Right,
in
but
it.
that's what I was trying to figure out. I don't, generally a bat would be way too large for a water holder in a bike, but, okay. But this was, as far as you know, this was a real baseball bat.
Right, right. There are water bottles sometimes that are sideways along the.
Okay.
Okay. So that's different. So the state of mind that was required for what he did with Passius, and then evidence that he watched Passius the next day on Passius's porch, because in a phone call to him, to Passius, he said, you know, I saw you waiting to be picked up today. So there was, and what in his, okay, so in his statements to police, he said, I have this gun because I need to take care of a problem. I'm going to take care of a problem. Someone stole money from me, referring to Passius. So that's a different type of crime. So it's not as if the mental state wasn't the same. So there's no analogy between the mental state for the Passius crimes, the multiple crimes, and in particular the last crime he was alleged to have attempted to commit, which is to actually go and kill Passius.
But would that not be, I mean, my memory, which is imperfect, is that he said he didn't usually carry a gun and was not carrying a gun on the day of the bat incident, but he did carry a gun that morning because he wanted to take care of something, which I assume was going to be Passius.
Yeah, I don't know that he mentioned morning because his questioning and the events occurred in the
day,
evening.
but basically he was wearing a gun that day because he wanted to use it for some purpose. We don't know what the purpose was, but that indicates planning. And the idea that you can't conform your conduct to the law when you think ahead to say, I'm going to be wearing a gun because I intend later that day to use the gun for some purpose. Doesn't that speak to his capacity to conform his conduct to the law?
Well, that wasn't the facts, though. I mean, the facts weren't that he was wearing the gun all day. He was wearing the gun when he locked Dorothy Philbrook out, that he was wearing the gun when he got angry at Dorothy Philbrook when she said, I'm going to call the police on him. There was no evidence. Certainly the issue was that he could have gotten the gun as soon as he was angry with Dorothy Philbrook and went after her. If he had been in the house, locked her out, and then as she walked up to the house, shot her, then this would be a different case because he would be laying in wait. He would already have had the gun. But he and she had been, according to the witnesses, he and she had been arguing even before the phone call with the son, had been arguing about what one of his obsessions was, that she had taken $50,000 from him over the years and spent it on scratch tickets. And so it was about money, it was about the scratch tickets. And then there was the phone call. So it wasn't, so there was these events that were going on between him and Dorothy Philbrook that then culminated in the threat to call the police and the shooting.
Wasn't there also evidence a week before the murder, the defendant told his granddaughter that he believed the victim stole money from him, and if he found out it was true, he would shoot her dead?
Right, but there was nothing, so yes, there was certainly a threat. There was nothing to show that, okay, now he learned that she stole $50,000 and he went with that threat. It was a threat showing that he was in the full throes of this paranoia and this irritability that ties back to his medications. He had started the requip 1 to 2 months before this incident, and witnesses testified that his behavior, although he had always been, perhaps an irritable person, his behavior had been much more intense in the previous month or so. So there certainly was evidence that this was brought on by the medications.
But wouldn't that have been true 2 days before? See, I'm having some trouble understanding if the argument is that his behavior was compulsive and he couldn't help himself, he couldn't conform his actions to the law, why he could 2 days before do something that you're saying is so completely different that's irrelevant.
Because there
I mean, I would think that it would be just that was just as bizarre behavior. Why wouldn't that be something that the defendant could just show he was out of control then too?
But the issue is that there was, at the time of the actual shooting, that there was this triggering event which separated it. And also the testimony was not that he was always psychotic, or it was that with this one event he lost it, and therefore he didn't have there was no proof of the element of first-degree murder, which was what of premeditation, which is what he was convicted of. But also, even if somehow the evidence would have been relevant, there are 2 additional reasons it shouldn't have been admitted. One is that there was evidence presented already that showed what the Commonwealth was trying to show with this evidence. One was that he could, in his police statement, remember that he had hit Passius 2 days before and where he hit him, so that, he had a memory, which the expert never said he didn't have a memory, but if the judge allowed it in, that was one of the purposes, but there was already evidence about that. The prosecution also wanted to show that he was, coherent during the police questioning. Well, the jury looked at the video, and even if the video had been redacted as the defendant wanted, where the Passius incidences and the threats were taken out, they still would have been able to see that he was able to make a phone call. The police said he was able to make a phone call, remember the number of the person who he called to say, I won't be able to fix your car tomorrow because I'm arrested for possession of a weapon. So that proved one of the things the prosecution wanted to prove, is that he could remember events during the time he spoke to police and he was coherent. The other reason is that he was able to plan the events, but he also had testimony that he was, again, you could use his phone call to the friend, that he knew that he had an appointment the next day, that he was going to cancel it, that he knew, and it was all non-prejudicial. And the other reason the Commonwealth wanted it was to show that he was able to appreciate what he was doing, and that, they said that the defense used this evidence against Passius to show that, how bizarre his behavior was confessing to police that he hit someone with a bat and he had a gun, and, his implication was that he was going to go, either get his money or shoot him. And so the argument is, it didn't help him to bring that in, because the expert wasn't needed to show that this was bizarre. I mean, the expert said, well, this just shows how out of touch with reality he was. Well, the jury didn't need the expert to say this was out of touch with reality. Anyone would know that bragging to police about assault and battery with a dangerous weapon and intent to assault with a firearm was inappropriate behavior.
You have to show abuse of discretion, which is hard for you. But I don't quite understand the nature of the unfair prejudice. I mean, the jury would have heard that he walked out and shot his wife, 4 times? That's pretty tough for a jury. So why would the jury be unfairly influenced by the fact that after having shot his wife, he appeared to be going to the club to maybe shoot Passius?
Well, because, a disgruntled worker going back to the workplace and shooting people is a very scary event. It's on the news all the time, and this was the implication.
So was shooting his wife. That's my point. It's not as if this is not a burglary case where they're offering this. This is a murder case where he's already shot his wife 4 times, so it's not as if we don't have that act of violence.
Well, I would argue that it's much more prejudicial, particularly because it was presented through 3 witnesses and the videotape of his statement to police. And when this court has accepted the fact that other crimes evidence was admitted, you would say, well, the trial judge limited the specifics about it. Well, it wasn't limited here. It was by 4 different avenues of evidence. It was argued extensively at closing argument, and that's another argument. It was one of the reasons was admitted to show that he was angry and he was upset. Well, as you stated, well, he shot his wife. We know he's angry. We didn't need to know that he was on his way to possibly shoot 1 or more people at his employment. It just wasn't necessary. There was other evidence there. And certainly it was more prejudicial than relevant, even if you assume for argument that it was relevant, because it wasn't just the bad attack. It wasn't just the stalking. And even Passius had stated that when Philbrook spoke to him the day before on the phone, he was, still out of his mind, babbling, and that although for years Philbrook accused him of stealing $700, he never attacked him before. So, there was evidence that this was new behavior. There was evidence that he had, and so what the defense attorney argued, and which is correct, is that you are only supposed to look at the evidence dealing with the crime itself when you're arguing that his mental state at that time was that he acted compulsively. And what happened was the jury was so distracted by this worse evidence that it's blocked out what the expert was trying to explain to them. Yes, it is very prejudicial that someone, just shoots his wife and kills her, and shoots her multiple times and kills her. And yes, that's bad enough. This was even worse. And in fact, it showed a different kind of behavior. And as trial counsel argued, the jury is just going to think, we never want to let him out. We don't want to find him guilty of a lesser offense than first-degree murder, even if there might be mitigating facts. We just don't want him out. And that was the problem with this evidence.
Well, on the prejudice point, wouldn't this kind of help your theory that this guy is compulsive and he can't help himself? He's just shot his wife 4 times, and now he's on his way to do harm to somebody else. I mean,
Well, but
you could make use of that.
well, but the benefit to the defendant was certainly outweighed by the prejudice, and also that the testimony was not just that he was, obsessing over people stealing money from him and bordering on delusional. It's that his actions at the time of the crime, because of the triggering event, he wasn't able to conduct his behavior to the requirements of law, and certainly the evidence about Passius didn't help. But there was an expert for the defense for the prosecution that was called in rebuttal and said that, well, I don't find that whatever his issues are on his MRI and his neuropsych testing, that really raised it to the point where he was insane, legally at the time of the crime. And he also stated that his medications, even though they were compounded, there were multiple medications, that they were not such that it would prevent him from knowing what he was doing or controlling his behavior. That was what the case should have been about, the experts, not about the Passius events.
All right, thank you.
Thank you.
Now, 1 second. Maura? There was no yellow light. There's no yellow light. For some reason, just
Good morning, Your Honors. May it please the Court, Assistant District Attorney Bethany Stevens from Middlesex, appearing on behalf of the Commonwealth. Your Honors, the trial judge here absolutely did not abuse her discretion in admitting this evidence. Essentially, what the defendant's argument is asking that the jury be misled by only permitting evidence of the single act of violence by the defendant. The jury was entitled to consider the full picture of events, especially where the issue in dispute was the defendant's state of mind. The trial judge recognized that when she heard the arguments on October 22nd in that transcript relative to the defendant's motion to sever the assault and battery dangerous weapon indictment. The defendant was also charged with the ABDW against Ernest Passius. It was the Commonwealth's theory, as set out in the motion opposing the severance, that it was a continuing course of conduct, that this was a motive that he had, that he was in an angry state of mind, and that these were choices that he made, decisions that he made, consistent with his personal motivations and desires, and not the result of some uncontrollable side effect of medication. The trial judge...
The judge did sever the ABDW.
She did, Your Honor. What she did was say that she felt that it would be helpful to minimize any unfair prejudice, basically to not allow the jury to consider those charges substantively, to be instructed on the elements of the crime and really focus on the crime itself. But she did feel that the facts themselves were admissible because they were highly probative on the defendant's state of mind. As you know, the model jury instructions that she gave that were consistent with the new ones that were just issued in the criminal responsibility instructions expressly provides that when the jury considers the defendant's state of mind, they can consider the acts of the crime as well as the defendant's actions before and after the event when they're considering the defendant's state of mind. To require the jury to consider the defendant's actions in a vacuum without any kind of context would really mislead and distort the picture and make it unnecessarily difficult and to a certain extent impossible for the jury to determine what the defendant's state of mind was. Essentially, what the defendant's argument is that there are different ways to view this evidence. The defense counsel very effectively portrayed the defense of a state of mind offense. It was fully and fairly before the jury. It was argued appropriately, both in the opening and in the closing by the prosecutor, which it was clear that she was prepared and thought out ahead of time, structured in terms of that the Commonwealth will prove the defendant's guilt by 4 evidentiary ways, the first being the testimonial evidence, the second being the physical and forensic evidence, the third being the defendant's statements, and the fourth being the state of mind evidence. And that's exactly what she called it as she listed this evidence, the defendant's state of mind. In the closing argument, when she talks about the defendant being an angry man, she talks about it in terms of it being the defendant's actions as a result of his personal feelings, his normal human emotion, as opposed to some uncontrollable side effect that caused him unable to control his behavior. It was never argued in any way that he did this bad thing and therefore you must find him guilty. And I would suggest that in a case like this, where the issue was not whether he was the one who killed his wife, it was his state of mind, that there really is no possibility of an unfair risk of prejudice, because that is the concern, is that the jury would be distracted and only look at this evidence and not give proper consideration and determine whether the Commonwealth met its burden of proof. I think both with the prosecutor's instructions, the judge's careful limiting of the evidence by severing the charge and then giving a strong, appropriate limiting instruction at the time of Passius's testimony, as well as in the final charge, made clear that the jury was only to consider it for that limited purpose. The jury deliberated on this case for 3 days. And so there's no suggestion that they were so inflamed by this conduct that they found that he shot his wife without assessing the evidence. And just to be clear, too, he shot at her 6 times. He actually struck her 5 times. He made clear what his intent was while he was shooting her. After he shot her, with the statements that he said, he was wearing a holster at the time. The evidence was then he turned around and reholstered his gun. And then when he was found an hour later, about across the street from the place where he had been fired, his firearm had actually been reloaded, and he was carrying further ammunition as well.
In the defense, were there 2 experts called?
There was, Your Honor. There was an expert who was the expert that interviewed the defendant several years after the incident. There was also a doctor from Bridgewater who, after the defendant had been incarcerated, there were signs of some kind of memory troubles, attention abilities, concerns about his competency, ability to interact with his defense counsel. And so that expert was called just to show the readings of the MRI and that there was some cognitive decline. However, as the Commonwealth doctor pointed out, and I think even the defendant's expert, there was some improvement afterwards, that some of that decline was a result of the withdrawal of many of the substances the defendant had used at the time. But again, the defendant was given the instructions both on criminal responsibility, the mental impairment as it goes to intent, and knowledge as would be necessary for first degree with respect to premeditation, extreme atrocity, or cruelty. So there's no complaint with respect to those instructions. So again, this is something for the jury to resolve. We can argue about what the actual evidence means, but that really is in the province of the jury. And I just want to point out, too, with respect to the cases cited by the defendant in their brief, all of those cases on page 27, and they're out-of-state cases, really stand for the proposition that it's a case-by-case determination. You can't say that there's a bright-line rule that swinging a bat at somebody or reloading a gun will always be admissible or will never be admissible. It depends on the facts of the case. It depends on the theory. And specifically, the case People versus Santarelli, that case was where there was a brother that shot his brother-in-law, and they were trying to argue that it was a delusional spur of the moment kind of a thing. And the court there actually upheld the general proposition that when you're talking about where the defense is that this was an isolated, impulsive act, the Commonwealth is entirely allowed to admit evidence of prior acts of violence to show that this wasn't an isolated incident. The court then went on to say that the judge didn't do the proper balancing there with respect to 2 of the incidents, because 2 of the prior violence incidents, there was no evidence about how they started. So it didn't tell you what was going on with the defendant at the time. He was engaged in this violence, but it didn't show that he instigated it, or so that was the basis for finding that there was an exclusion there, not that this evidence isn't relevant. And then just another point to make is that the judge was very aware of the necessary balancing test here. During the George son's testimony, because he was the one that was on the phone with the defendant and the victim at the time, at the end of his testimony, the prosecutor approached sidebar and asked that she was interested in exploring or eliciting prior acts of violence between the defendant and the victim, and just prior, I think there might have been other acts as well, not associated with the victim, that she would be seeking to elicit in rebuttal to a claim that this is this isolated violent act. The judge said that it would be unfairly prejudicial at this point, that the door hadn't been opened. Then during cross-examination of the defendant's expert, the prosecutor again was trying to set the foundation that the expert's opinion was that this was an isolated violence and never before the recap had he been violent. The court there, again, declined to allow her to go down that road, finding that it would be unfairly prejudicial. So the judge, I would say, absolutely made the decisions well within her discretion, and I would suggest, did a commendable job in ensuring that the defendant's rights were protected in this case. And with respect to 33, I would suggest that the Commonwealth's evidence was very weighty with respect to first degree, and as this court has recognized, when it's been fully and fairly before the jury, there's no reason to set the verdict aside. If there's no other further questions.
All right, thank you.
Thank you, Your Honors.